Okay.
Thanks everyone for joining us this afternoon. It's really appreciated. Unfortunately, Debbie, Debbie can't make it today. As you can probably appreciate, FCSA are quite busy at the moment with lots of questions and queries. But we really do appreciate you, Chris, giving us your time to run through, what these regulations mean for agencies. And I know that the format for this is you've got a presentation that you're going to kind of run through.
Okay.
I'm
Thank you.
going to ask some questions as we go through, and then at the end of that, we're going to open up the forum for people to raise any questions that they have. They can go into the chat, I'm assuming, Chris. And
yes.
Obviously, should you feel brave enough to do so, take yourself off mute and ask the question or raise your hand, basically. So, obviously, Chris just alluded to the fact that very, very busy. The announcements on the 21st of July, just a week and a half ago now, probably been quite hectic.
It has been, yeah, and I'd just like to take this opportunity to thank government for dropping the legislation at 5:15 on a Monday evening, which meant that me and my team were largely still working at about midnight. So.
I think most of us were, Chris. I think we kind of waited all day and thought we might not hear anything, and just as we're on the drive home, it pops into your inbox, doesn't it, basically? Yeah. But having seen the content today, I think this is going to provide a lot of detail, a lot of reassurance, hopefully, in terms of what needs to be done. So without further ado, I'll hand it over to you, Chris, just to take the lead, if that's okay.
Okay, I'm just going to share my screen with the thing. Absolutely hate Teams, but got there. There we go. You can see that clearly, Chris?
Yeah. I can see that.
Good. Okay, so this is a fairly short but comprehensive presentation. Chris has a few questions that he's going to ask during the presentation, and I'll try to answer them. But at the end of the presentation, there'll be plenty of opportunity for people to either put their hand up if they want to speak or put it into the chat, and we'll keep our eyes peeled on the chat to answer any questions that you might have. I'll try not to go too fast. I've been accused of speaking too quickly and moving too fast. On the other hand, nobody wants to be bored to death by PowerPoint. So a little bit about FCSA. Most of you probably already know this, but we are the leading experts in compliance in the temporary labour market, and particularly around service providers. We are the broadly accepted gold standard for accreditation. What might not be known is we are the only not-for-profit in the sector. We do this not to make money out of it, but to raise standards across the board in the sector and just make sure that everybody is doing the best they can. And importantly, FCSA assessments, which Parasol have undergone, for example, are carried out by the best-in-class professional service companies. They have specialist teams who perform the assessment process, consisting of about 780 different questions, covering about 20 different areas of operation in an umbrella, of which, of course, PAYE is a relatively small but very important part. And those assessors, companies like EY, BDO, Safri's, I mean, well-recognised, well-known names. And Parasol themselves are FCSA accredited for both umbrella and CIS operations, and they are also live on FCSA's Diligence Hub, and a little bit more about that later. So the legislation, well, a bit of background first. In 2022, there was a call for evidence, and importantly, that was issued by the Department of Business and Trade. It was actually called BEIS in those days, but it's now the Department of Business and Trade. And we submitted a fairly substantial document alongside about, I think there was 30 or 40 other organisations submitted documents to that call for evidence. And we have always been, FCSA has always been of the view that the umbrella industry should be regulated. In 2024, the government issued a consultation document on regulating the umbrella market. And that was issued actually by Her Majesty's Treasury. And it was very clear almost instantly on reading that consultation document. It was all about the money, very little operational detail in there. It was all about closing the tax gap and making sure that umbrellas were operating compliantly as far as the money goes, which, yeah, we can agree is important, but it's not all that umbrellas do. In October last year, the Chancellor announced that she preferred option 3, which internally we call the nuclear option, which would have basically transferred the liability and responsibility for the operation of PAYE to recruiters and employment businesses. And we knew instantly that that would be a fairly poor path to go down. It had huge implications on how the industry works. It would have been bad for agencies, very bad for agencies. It would have been bad for your candidates, and it would have been bad for HMRC itself. So we engaged, we formed a team, industry working group, consisting of REC, APSCO team, some of the software providers, the umbrellas, and a few other interested parties. And we also engaged Rebecca Seeley-Harris, who's a tax policy expert, to look for alternatives to the option 3. Earlier this year, we produced a fairly substantial report, about 90 pages. It's available on our website if you'd like to read it. It will send you to sleep. Detailing the problems with option 3 and making a couple of suggestions that the Chancellor might like to consider as an alternative. And then we had dozens of meetings with MPs, peers, HMRC and HMT. And then Rebecca, with our support, proposed joint and several liability as a solution. And in June, government sort of gave us, not quite on the QT, they were fairly open about it, that that was the option they were considering. And as we just referred to at the head of the meeting, on the 21st of July, the finance bill contained that option, joint and several liability, which is now government policy. I think it's a big win for Rebecca, FCSA, and in fact, the industry as a whole. So what are the tax regulations? Well, straightforwardly, it's a brand new chapter, Chapter 11 of ITIPA, which sets out the tax liability rules for us. It's effective from 6 April 2026, and that date will not change. It introduces joint and several liability, where relevant parties, and we'll come to that later because that's actually really important, in the supply chain, agencies and end users will share liability for PAYE payments. That sharing of liability applies to the whole amount due, and obviously including any shortfalls or underpayments, regardless of the reason for it. And that is key, that's quite important. So there are also no statutory excuses. The legislation applies automatically. Any smokescreens will be ignored. Any offshore entities will be ignored. There is no escaping this. There are no statutory excuses. So you just have to understand that this will happen automatically. And we'll come to how it will happen a bit later. The regulations stipulate a very broad definition of umbrella companies, which includes employment businesses and other intermediaries directly engaging workers under a contract of service, employment contract. So an employment business which has its own PAYE in-house function and employs workers through that function is regarded as an umbrella company, not an employment business anymore. You'd be regarded for the tax purposes as an umbrella company. But under no circumstances are recruiters or employment businesses being deemed the employer, which is a very good thing, because that means that the umbrella remains primarily responsible for PAYE, and the ERN in use will still be the umbrellas, and all liability and responsibility for the sticking to employment law and providing employee rights will still be the umbrellas. That's fairly crucial in the relationship that you have with your candidates. Once they're engaged by an umbrella, if something goes wrong in terms of their employment and they decide to go to a tribunal, agencies would not normally be involved in that tribunal at all. It would be the umbrella company. That remains the same. That it's more or less business as usual. There won't be any requirements to change employment contracts, and there'll be no changes required to kids or anything like that. So in terms of immediate administrative burden on your businesses, there'll be very, very little. One recommendation FCSA always makes when we talk about kids is use the right phrase, use assignment rate rather than any other term. And the reason for that is that if it's capable of being interpreted as this is your salary, then it's possible that an employment tribunal will find that the employment costs, employers' national insurance, apprenticeship levy, etc., should be taken out of the agency fee and not the assignment rate. So you have to be very careful about that. And in fact, an ET just handed down a judgment on holiday pay on just that basis. And even the employment judge said it was the kid that a mistake in the kid that caused that problem. So coming back to the relevant party, what does it mean? Well, the way it's worded suggests that the topmost agency in the chain, employment business or recruiter in the chain, the one with the contract with the client, will be the entity that becomes liable, even if there's multiple agencies involved. It's the topmost. So it's exactly the opposite of payroll working IR35. It's the topmost agency. But if there's no agency involved, i.e. the relationship is directly between an umbrella and the end client, then the end client will be held liable. But, and this is important, if an MSP, a master service provider, or an agency is connected to the umbrella, and that could be a joint venture, it could be common directorship, it could be common shareholders, the end client is still going to be held responsible. Connected is sufficiently vague that you might need to examine some of your relationships if you carry out business that way. And importantly, if the topmost agency isn't UK based, the end client may still be liable. That's a very rare circumstance, and we'll cover some of this a bit more graphically, slightly more easy to follow a bit later in this presentation. One important note is master service providers are included even if they're not in the payment chain. So they would be regarded as being held liable because they're effectively the employment business, even if they're not in the payment chain and they're just organizing the paperwork. And then there's another new phrase, purported umbrella, which is massively broad and is cleverly designed, I think. It says here appears designed, but it's cleverly designed to catch mini umbrellas, any other fraudulent arrangements which utilize compliance loopholes, unlawful gross pay models, such as false self-employment. They've introduced this because they don't want the circumstance to arise where the relationship between the umbrella and the worker is in some way disguised as not being umbrella-like behavior. And what they've said is somebody in the supply chain could reasonably look at the way an organization is behaving and assume it was behaving like an umbrella, then HMRC will regard it as an umbrella. So they've left it quite woolly, and I think, in fact, it's quite smart the way they've done it. But broadly speaking, as it says there, if it looks like a duck, etc., it is a duck. We've been asked about national insurance contributions because there's no mention of that in ITIPA, because ITIPA is PAYE taxes and income taxes. And the government have already announced that they will be amending Section 4A of the Social Security Contributions and Benefits Act 1992 to basically impose an equivalent JSL for NICS purposes. A bit later on, we'll find that they're also going to amend that act to include apprenticeship levy. And there will be amendments to other pieces of legislation, Chapter 10, to prevent fraudulent document condition. And this is to prevent agency receiving fraudulent statements from a non-compliant umbrella being used as an excuse to try to get them out of being joint and severally liable. So even if the umbrella is providing fraudulent documents to your agency, then that unfortunately is not going to let you off the hook. And
Chris,
HMRC,
just at that point,
yeah,
sorry, Chris, just at that point, that's a bit of a game changer, now, isn't it? Because we've already seen since last Monday companies purporting that they've got a way around this. And that would only be via fraudulent documents or a KC's opinion that, you know, anyone's likely to give. So what does it specifically mean? What kind of fraudulent documents would you be providing?
I don't want to put myself at risk of getting sued, but there's a case currently before I think it's the High Court where HMRC are pursuing an organisation working in the healthcare sector primarily with the NHS. They're pursuing them for 170 odd million of unpaid national insurance contributions, where that organisation has allegedly furnished fraudulent documentation such as payslips and RTIs to agencies who are working with the NHS, giving the impression to the agencies that the workers involved were on their books as employees, PAYE employees, which initially they were, but after a couple of months they were hived off into personal service companies or self-employed and paid gross. But unfortunately, the umbrella, non-compliant umbrella, allegedly continued to provide fraudulently devised, basically made up payslips and RTIs as proof to their agencies that they were operating PAYE. So it is a bit of a game changer. It will enable HMRC just to say, well, getting copies of fraudulent documents, forgeries, if you like, isn't good enough. We're still going to demand that you're now, well, insist that you're now liable for unpaid taxes.
Yeah, definitely. Just on the next point before you say it, there has been, and we've had a few people who've kind of think this is some kind of transfer of debt, which it clearly isn't. And the imposition of a Reg 80 determination, I think, illustrates that, doesn't it?
Absolutely. This is not transfer of debt. This is joint and several liability. And this is a sort of fairly commonplace concept in everyday life. If you have a mortgage jointly with your spouse, you will be jointly and severally liable. So if you don't pay it and your spouse doesn't pay it, you're both in trouble, as it were, if I can put it that way. And joint and several liability. It's a concept that's already been used by HMRC and Treasury in other circumstances, which we'll come to later. They're basically saying, no, the liability is there, and the Reg 80 notice or determination is just us saying that's how much it is. Now, clearly, they have to go and work that out, which might take them quite a long time, to be honest. But it's very clear. This is an automatic process. They don't need to go to tax tribunal. They certainly don't need to go to court. They just do the sums and issue the agency with this Reg 80 determination. So, which is, potentially a bit scary, but we've got solutions, so let's not worry too much about that. So, One thing that's worth noting is the genuinely self-employed, and those are deemed already to be employees for tax purposes under chapters 7 through 10 of ITPA. So agency workers, etc., IR35, managed service companies, and various other off-payroll working roles are specifically excluded from the new chapter 11 because those existing chapters take precedence. So that's actually just a very fancy way of HMRC saying it's business as usual for everybody except umbrella employees. So, which is, it's no different from how it's been for some time now. So where does the liability land? Well, we've got a vanilla supply chain here. This is the simplest supply chain that we see commonly. Where you have a non-compliant umbrella working to one agency in a chain who works in turn to the end client. As you see there with the red border, the agency would immediately be liable here. So anything with a red border is where the liability ultimately can land. And clearly a non-compliant umbrella would, in theory at least, have the primary responsibility, but because they're non-compliant, any shortfall or any amount of tax not paid will fall to the agency. In a slightly more complex supply chain, and I've made this as simple as I can to illustrate it, where you have a non-compliant umbrella at the end of the chain, you have an agency working to a tier 2 agency working to a tier 1 agency. Then the tier 1 agency, because it's nearest the end client and holds the contract with the end client, would be liable. And similarly with an agency working to an MSP, and of course I appreciate there could be multiple agencies in these chains, an agency working to an MSP is closest to the end client. So the MSP would be liable. And in direct engagement, where there is no agency involved at all, the non-compliant umbrella, the liability incurred would be placed on the end client. Now, this is the connected umbrella. So a connected umbrella, as I say, is an umbrella which is, generally speaking, has common directorships or common shareholding or common shareholding, or is in a joint venture with an employment business. Simply put, in that circumstance where there is no other agency involved, the end client would end up as being liable because HMRC says that the connected non-compliant umbrella and the agency are one, as far as they're concerned, one and the same entity. There's no other agency in the chain, therefore it's the end client. If there was if there was another agency in the chain above the agency in red and grey there, that agency would be responsible. And that's something I should probably put on this diagram. And I will do, Chris, for onward distribution.
So, just on that point, Chris,
yeah,
that's really interesting because there was numerous commentators in the run-up to the legislation being kind of confirmed that were, particularly on the recruitment agency side, were saying, well, we'll just set up our own umbrella company to get around this. Or there were some that already had umbrella companies connected or I'm sure had JVs in place.
I'm sure that some of those arrangements are perfectly legit. I mean, we are specifically talking about non-compliant umbrellas operations here. The idea of setting up your own umbrella and being an umbrella, by the way, isn't easy. But the idea of now just going off, so we'll set up our own umbrella and that solves the problem for us, it absolutely doesn't. In fact, it probably makes your problem worse, because the end client won't want to deal with you, because the end client will know that because of your arrangement, they could potentially be liable. And we'll come to a couple of behavioural changes later on in the presentation, which sort of acknowledge people's growing awareness of if you like, de-risking their own businesses. So coming on to offshore entities, this is a very simplified version of it. But basically, any offshore entity in the supply chain will be totally ignored, and the agency nearest to the end client will be held liable. Now, there is a question that I've seen about the whole chain being offshore, and that is that's a problem that HMRC will have to deal with. But the likelihood is that anybody supplying PAYE workers in the UK, the workers themselves, would have to be working in the UK for a UK-based end client, even if the end client is registered offshore. So basically, HMRC will just totally ignore anything that is based offshore. And in these two particular examples, in both cases, the agency nearest the end client, i.e. the UK-based agency, nearest the end client, would be held liable. So how do we de-risk the regulations for agencies? Well, people on this call, you're off to a great start. You already work with Parasol, FCSA accredited umbrella. But I think we can all agree that things might have to be even more tightened up. We would recommend that you make sure your PSL becomes an assured provider list, and we of course say that it's only FCSA accredited umbrellas. You can take steps to make that happen by becoming an FCSA recruiter partner, and we can help you then with various insights and mitigation tools. I don't want to sound the sales alarm too early in this bit, but FCSA Recruiter Partnership is entirely free of charge. We just have to sign a couple of agreements, and Bob's your uncle. Work with your provider to ensure trust and mitigate risk, and I think this is going to be very important. You can keep ahead of the curve with FCSA's Diligence Hub, which Parasol already use. You can verify payroll accuracy and HMRC remittances, and that's pretty obviously going to be valuable with another tool that FCSA backs called Veripay. Very low cost services. They do all the heavy lifting for you. But due diligence on your part, proactive due diligence on the part of agencies, is going to be absolutely essential. Whether you use our tools or anybody else's, it doesn't really matter. You've got to do this. And we can help recruiters build on their existing processes to take all of that into account. I mean, clearly, to de-risk as best you can, taking these steps is going to put you in a really good position. Don't fall for unrealistic incentives. They're simply not affordable for any compliant umbrella. I mean, there isn't a week goes past when I don't see an agency being offered, £500 per candidate to push them onto a specific umbrella. Realistically, that's just not affordable. Never was always a great indicator of non-compliance. Don't fall for any outside the regulation schemes. We've already seen one. I've actually got the documentation, Casey's opinion and all, and we ran it past our own legal experts, again, independent of FCSA, and they came back and said, well, one, the scheme is already unlawful, and two, there's no way it avoids Chapter 11, and three, you should report these people now to HMRC, which we've done. Any outside the reg schemes just isn't going to work, and that's because you have this purported umbrella wording, which spreads the net very wide as far as HMRC is concerned. Those schemes just won't work. The good news is payroll pirates will be easier to spot for us, for agencies, and indeed for other umbrellas. And when we get information about these, we do report them to HMRC, and ultimately we will be working with the Fair Work Agency on those as well. So in terms of some FAQs, these are FAQs we've had already, so maybe short circuit some of the questions that you'll have at the end of this presentation. Will MSPs be on the hook? Well, yes, even if they're not in the payment chain. When will it hit Parliament? It normally goes through October, November. There is a formal consultation period up to September 15th, which gives FCSA and others a little time for further input and to ask for clarification. The bill is not going to change substantially, and by convention, really, the finance bill goes through in the nod. It's very rarely challenged in Parliament. Liability for VAT, Chapter 11 doesn't mention that. That's because it doesn't have to. Unpaid VAT is already well covered by case law, Cattell and ICL, for example, and joint and several liability already applies to any unpaid VAT in a supply chain by using VAT Notice 726. And we think one of the reasons that HMRC went for the joint and several liability is they already use it. So anybody coming to you with a new get off the hook for VAT scheme, some sort of loophole, because of Chapter 11, it's not mentioned in Chapter 11. Well, it doesn't have to be because the existing legislation is already there. And you'd end up in for a very nasty surprise because HMRC actively pursue those cases. Liability for apprenticeship levy, we've confirmed it will be covered by changes to the Social Security Contributions and Benefits Act. So that's going to be covered. A couple of agencies have said we've had approaches about a flat rate VAT scheme that can help us. Are these legit? Rarely. We see them quite a lot. And again, one of the clues is great rebates or great incentives, which are way above industry norms. Barge pole rule should usually be applied with those. And one question is, have the government just made the whole industry into a self-policing tax regime? The short answer to that is yes. Quite smart on their part. It means that they can do a great deal of work. We can do a great deal of work on their behalf. But twas ever thus. I think VAT, for example, I always complain that we're unpaid tax collectors. So, and lastly, on FAQs, we've been asked about behavioural changes in the industry, and yes, we have. We think we'll see a combination of all or some of these. We think end clients and MSPs or Tier 1 agencies will start to require the use of FCSA accredited providers. I think, for certain, and we've already seen this in the 7 days since the is it 7 days? No, it's not. It's 9 days since the legislation dropped. We've already seen a huge uptake in both applications to become FCSA accredited. Have to tell the bad news is that normally takes a year in the first instance, so maybe left it a bit late. But a massive uplift in proactive and robust due diligence. We've already seen many agencies and umbrellas come to us to talk to us about VeriPay and Diligence Hub. End clients who are direct to umbrella, and this is good news for the agencies on the call, possibly slightly less good news for the umbrellas, unfortunately. Sorry, Chris. Will likely want to start to use agencies. So those end clients, and there's not that many of them, but those end clients who have in-house recruiting and just use an umbrella to do the PAYE will likely want to introduce an umbrella into the supply chain. And bluntly, that de-risks for them, because if they have an agency in the supply chain, they would not be liable for any unpaid PAYE. So it's a behavioural change we'll see. It's a good circuit breaker for those end clients. We may see some end clients requiring that agency workers for their employees are shifted to umbrellas for precisely the same reason. It basically, I think that a smart end client, knowing that they had hundreds of temporary workers who are on the agency books as employees, be clear about that, as employees, would likely want an umbrella to be shifted into the chain. End clients and MSPs will be requiring due diligence, and I have no doubt that they will be monitoring the quality of the due diligence that the entire supply chain carries out. And as part of that, I suspect there's going to be, well, I know there's going to be, because we've been asked about it already, indemnities up and down the supply chain. And I think that that's going to be that's certainly something that FCSA are working on with our members, and I think that hopefully in the pretty near-term future, we'll be able to say to our members, here's the way to do it, and here is in fact the policy that you can do it with.
Yeah, from my understanding, Chris, I think there's quite a few providers in the market that are looking at the insurance view, and it's probably something that will be needed as kind of a wraparound on all of this as well.
So. Absolutely. I think that I know that Mark Allen Kudos, all the providers that currently operate in our industry are looking into this as a matter of urgency. One of the problems with that, of course, is we have to explain to them how umbrellas work and why the liability isn't billions of pounds. So
yeah. That's an important thing, though, isn't it, Chris? There's lots of commentary about racking up millions and millions of pounds in this, but essentially that's never going to be the case if you're keeping an eye on this. You've essentially got a 6 to 7 week period, aren't you, where the liability builds up, paid, and you're closing that chapter each time, basically.
Yeah. So if you're using a tool like VeriPay, for example, so those of you on the call that don't know this, the liability for PAYE accrues during the working month, as it were, and at the end of the month, is it today? No, tomorrow. The end of the month, that liability pretty much crystallizes. All the RTIs are in for the month, and the debt has to be paid on the 22nd of the following month. So it's fairly clear. HMRC have all the information. VeriPay has all that information, and VeriPay checks on the 22nd of the month that the payment's been made. So as Chris says quite rightly, the liability before the warning flags or the warning bells are sounded is at most 6 or 7 weeks. Whereas if you take a sort of an uneducated view of it, which some insurers might do, think, well, my goodness, these people have 4,000 employees. The liability could be billions of pounds if they rack it up, but that's not quite true. So moving on, just finally, what do FCSA think of the draft regulations? Well, basically, we think they've done a pretty good job. JSO, as we're calling it, is way better than the original option 3, which would have been massively difficult for agencies, umbrellas, workers, and in fact HMRC to deal with. So I think government have listened to the evidence that we supplied to them and come up with a pretty slick idea, and a pretty slick way of doing it. We like the fact that the umbrella definition is quite wide, and we like this purported umbrella concept because one of the warnings that we gave government was that the payroll pirates will just invent another business operating model to get around any regulation that is specifically targeted very narrowly at a specific type of business process. So we quite like that. I'm sure there's some players in the market that don't like that, and those are probably the ones that you shouldn't be dealing with. We think it will help close down the payroll pirates, very much so, and it will help close the tax gap. The caveat to that, I have to be honest, is that HMRC will actually have to police this regulation properly and prosecute it properly. And we all know that HMRC are kind of under the cosh resource-wise. Certainly there's 5,000 new tax inspectors being recruited as we speak. Off that 5,000, a very small percentage of that will be looking at the payroll industry and umbrella industry. So it's going to be key that HMRC actually do take action where they find wrongdoing. Importantly, and this is something that I think a lot of people didn't really understand, the outcome for your candidates is way better than option 3. So it's not necessarily very common, but where a candidate is working maybe 2 or 3 contracts for different end clients through different agencies. So he's doing 2 days there, 2 days there, 1 day there. An umbrella brings all of that together. An umbrella can offer salary sacrifice, etc. And we looked at the machinations of basically all the recruiters trying to organise that themselves, and the candidates would have been out on all sorts of benefits, and who's going to pay the sick pay, who's going to pay holiday pay, etc., etc. So the outcome for your candidates is really good. Obviously that goes hand in hand with the outcome for agencies being really good, because they don't have to worry about any of that stuff. The umbrella does all that for them. And I think that's one of the great benefits of using an umbrella company, is all that nightmare administration over and above just doing a sum is done for you by the umbrella. And at last, the supply chain will have the ability to compete on a level playing field. There is no doubt that some of the, especially the big headline ones, some of the problems have been caused by payroll pirates offering massive incentives to agencies. And I don't want to be brutal, and I'm sure that no agency on this call would be involved in that. Agencies have turned a bit of a blind eye to it, because those incentives were really impressively high in some cases. And I think that will actually just clean up the entire industry. So I'm quite pleased about that. So moving on, I'm going to stop the screen share now. If you have any questions.
Yep, so Chris, there are some in the chat already for you. Yeah, okay, they're already here. So there's one from Becca Campbell. So is the non-compliant umbrella company never liable? It's a good question.
It will absolutely be liable. However, and again being realistic, what a non-compliant umbrella company, there's 2 types, right? Let's be honest here. There's those that get the sums wrong or miscalculate because they don't necessarily, they aren't necessarily using the best software, for example, and they might have a few quid, maybe shortfall in apprenticeship levy. That's one form of non-compliance. Normally speaking, and we've seen this as FCSA, when we've been checking things, we say actually the methodology you're using to calculate and apprenticeship levy is actually a good example of this, is slightly wrong. Work it all out using this methodology, and it's maybe over a year, it's a few quid per candidate. So what they do is they go back to HMRC, say, we've made a mistake, and here's the check. That's non-compliance. Then there's non-compliance on the deliberate and massive scale, where basically an umbrella, a non-compliant umbrella, is operating in such a way that it has no real intention whatsoever of paying the right amount of tax. They may be ostensibly deducting the right amount of tax in some cases, but they're pocketing some of it and not sending it to HMRC. Pretty well criminal. And then there's the umbrellas who try to, non-compliant umbrellas, payroll pirates, who try to convince the agency that this scheme works, loan schemes or gross payment models work or whatever. They'll be caught by this very, very quickly and very easily. And then there's another form of non-compliance, which is basically a non-compliant, a payroll pirate, who will lie to an agency and provide faked evidence. And this legislation will put them out of business too, because the agencies, because they're carrying the risk, will actually do their jobs better, maybe.
Yeah.
We put it that way, Chris.
Yeah, and I suppose the whole purpose of the legislation is to close down, to take the oxygen away from those non-compliant providers, isn't it? So hopefully that's what this can do. The next question, Chris, I don't know if you can see it in the chat, it's quite a lot. It says,
Yeah, I can.
in terms of the connected umbrella, I thought the purpose of the changes was to stop the end client being liable where those businesses are connected. And then, Debbie, you've inserted some commentary there. Is that from, or where is that from, I suppose?
That commentary is from the Professional Passport website.
Okay, thanks, Debbie.
Yeah. I'm just reading that carefully just to understand what it means. Where it sits between the provider and an agency and the liability is not paid, it can't pass up to the end client.
Yeah, so just to clarify, the illustration you put up earlier said that in that case, the client would be liable, but from what I understand, they wouldn't be, because otherwise...
I think Crawford and me are actually saying the same thing a different way, because he says that is additional measures within the rules in an attempt to close a potential loophole of a rogue organisation owning both the provider and the agency, which is kind of what we're saying in the connected entity, where if there is no other agency in the chain, i.e. The agency and the umbrella, the connected umbrella, are operating directly to the client, it's as if the client will be held liable because it will be regarded by HMRC as no agency in the chain at all. Now, if there's a connected umbrella, non-compliant umbrella, and a connected agency with another agency, a tier 1 agency in the chain, it would be the tier 1 agency that was liable. So I probably need to add a line to my diagram there.
Is that okay, Debbie?
Yeah, I think so. Thank you.
Okay, thank you. So the next one was from Nana. This is Parasol related and marginally. I think I know what you're talking about there, Nana, if that's how you pronounce it. What I'll do is if I can reach out to you directly on that and we can make sure we understand the question. That's okay. Question from Judith. JSL surely indicates the agency and umbrella are jointly liable for any unpaid tax. Your slides indicate liability falls on the agency, not the umbrella.
Yeah, sorry, I should make it clear. We're assuming here that the umbrella has not paid the tax and cannot pay or will not pay the tax. So we're really talking about non-compliant umbrellas here. Yes, you're absolutely right. The umbrella and the agency are jointly liable, but the assumption, maybe I should have made that clear, the assumption is that the umbrella has done something wrong, which would cause HMRC to go after the agency to get the unpaid tax. If the umbrella's done nothing wrong, then you've got nothing to worry about.
Chris, what's your view on where I know they can go to any part of the supply chain agency or umbrella. Where do you think they will go to first?
They'll always come to the umbrella first.
Yeah.
And there's two reasons for that. One, that's the obvious source of the unpaid tax that should have been paid. And secondly, they would have to quantify exactly what the Reg 80 determination is on a per umbrella, per agency basis. There is no question, and we've already had this clarified, there is no question that an agency is going to become liable for unpaid tax for candidates that they didn't place. So all the calculation has to be done down at the umbrella side. So, and that would be the first port of call for HMRC.
And of course, that would rely on the agencies obviously submitting their RTI intermediary report to HMRC as well, so they can see the flow of money. What's been sent to each umbrella company, I suppose.
Yes. So in an ideal world, and I think we and Crawford, Professional Passport, has been particularly vocal about this over the last oh God, I don't know, 7 or 8 years, I think. If all agencies regularly put in intermediary reports and umbrellas all put in their RTIs, and HMRC looked at their bank accounts, and if HMRC could actually join all of that up internally, the problem kind of would be solved. There might be some other issues elsewhere, but they haven't been able to do that. They've always said that they can't do it because it's, left hand isn't allowed to talk to right hand, never mind actually know what they're doing. But so basically the market, Veripay, for example, we can take intermediary reporting. We do take the RTI, and we do look at the payments, and we can reconcile the whole trail. So
there's also some investment, isn't there, Chris, from HMRC for their IT to try and
that's to track
this up as well?
employer reference numbers. I'm not entirely sure what they mean by that. I think
still requires the RTI from the agency, though, doesn't it, for it all to match up?
That intermediary reporting from the agencies, which is only quarterly, and I have to be honest, not all agencies bother to do it, although they should. There's a legal obligation for them to do it. They just don't bother. So, which is not great.
Okay, next question from Joanna James. So if this is coming into effect from April 2026, does this mean that up until that point the tax liability is solely with the umbrella? Therefore, any tax not paid by the umbrella up until that point is with the umbrella?
Yes, that's exactly correct. There is one circumstance which will not. It is technically possible that HMRC might regard joint and several liability as being in force for tax prior to April the 6th if the payment is made after April the 6th. It's the usual problem with minimum wage, for example.
When the work was carried out compared to
when the work was carried out, yeah. So, by and large, I mean, that liability would be limited to a couple of days, if it exists at all. But no, the legislation isn't retrospective. It will not be seeking any underpayments from agencies for historical underpayments from any umbrellas.
I think a word of warning there, I suppose, though, Chris, is that, and nobody on this call, I suspect, will need to worry about this, but there is a requirement from the Criminal Finance Act perspective to report where you found this kind of thing in your supply chain. So for those agencies that have proliferated these schemes, it's not just as easy as going, we'll get to the 6th of April and change that. There is the imposition that they needed to do something ASAP and report that to kind of move on, I suppose, isn't there?
They should be doing. I think in fairness to agencies, I'm sure that some agencies do that. I think one of the problems is that these payroll pirates, I mean, some of the schemes are quite clever, and very well sold. Lots of King's Counsel opinions floating around. I hope there's no lawyers on the line, but you put 2 lawyers in a room and get 14 different arguments depending on how much money you've got. It's sorry, I don't know, Chris. You're not a lawyer, are you? I'm just insulted you. That's one thing. It's just the schemes are actually quite clever, and the other thing is the payroll pirates will provide false evidence. So by the time the agency actually finds out that the payroll pirate is doing something wrong, it's too late. The damage is done, as it were. I think, as we say, this legislation kind of turns the industry, the whole vertical, into a police force, and you will be expected to report any wrongdoing that you find, both under this act, because you're going to be liable for it, and under the Criminal Finances Act, definitely.
Thanks, Chris. So next one is a really good question here from Kevin. So today, if an umbrella company went bust, the agency is not liable as it's B2B contract under normal law. In the future, if an umbrella company goes bust owing a large amount to HMRC, how would this play out? The next part of that, I think you've already answered, is with regards to proportionality calculation, is that yes, the feeling is that they would look at that and work that out. Chris, is that correct?
Yeah, absolutely. Proportionality is if it's 5 workers, you would only be liable for those 5. The question as to whether an umbrella goes bust, just through the normal course of business, not having done anything naughty, but it owes a large amount to HMRC. Well, as we explained earlier, the most it should owe to HMRC at any given point is about 7 weeks worth of money. So it's not going to be a huge amount of money. And this ties into the next question nicely, in fact. So yes, the answer is that the agency will be responsible for umbrellas going bust. Whether HMRC enforce that, it would be, I don't know if they will or not, and it's something that I might try to clarify with HMRC, because it does seem to me that if an umbrella goes bust, just through running its business, classic example, I'm afraid to say, is that an agency goes bust owing the umbrella a great deal of money, then the umbrella is a serious financial risk. And the other thing, I shouldn't say this because it looks like I'm trying to flip the blame onto other people, which I'm not. This is just a fact of life. If agencies push for unrealistic credit terms, and the umbrella acquiesces to that because it's the only way it can get business, but the agency, either the umbrella can't afford or the agency isn't suitable for credit insurance, you kind of have a perfect storm coming along there. So there's business reasons that an umbrella, perfectly legitimate, perfectly compliant umbrella, might go bust. And that, I'm not sure if HMRC would just say, oh, well, we don't care about that, we're going for the agencies.
I think it plays a part, doesn't it, Chris? Sorry to cut across you there. It plays a part in terms of, in that question about what other due diligence should you be carrying out. That should be part of it. Ongoing due diligence from month to month, basically.
So FCSA have a liquidity requirement that we apply to our members to make sure that they're financially stable. That doesn't mean to say that they can't hit trouble if 2 or 3 of their agencies were to go bust, owing them a great deal of money. That would cause them problems. But coming on to Judith Hull's question here, agencies don't have the time to be checking all the payslips. Correct, you don't. That's what VeriPay does it for you. And it just says, of the 10,000 payslips issued to your candidates this month, these 2 need your attention. Or this umbrella hasn't paid its crown liabilities. So we do it for you. And it's, I'm trying to remember what the price is. Roughly speaking, it's 60 quid a month for an agency to use that service for all its umbrellas, not per umbrella, which is what, I don't know, a couple of cappuccinos a week. So there we go.
Just conscious of time and the fact that we've run out. No, it's okay. So, Hannah, Craig, as we work with Parasol, what are our next steps? Obviously, we'll do our due diligence, but will you be sending a compliance plan? Yes, we are currently putting together a guide that will be sent out to all of our agency partners, hopefully by early next week at the very, very latest, Hannah. Do you want to just come back there to go in the payslips, and also not all candidates may want to provide their payslip to agency. I think as part of any kind of payslip auditing, Joanna, I think it's non-negotiable that all payslips would be submitted to that provider. Right. The right due diligence and GDPR requirements will need to be put in place for that. But there will be an option to opt out, and that would obviously then be passed along to the provider in that case as well. I couldn't understand why an employee of an umbrella company wouldn't want their payslip checked, but there are some, I suppose. Are we, the agency, liable if the compliant umbrella company goes into liquidation? We've just touched upon that. The illustration suggests that agencies will always end up liable when using a non-compliant umbrella company, even if they are unaware of the non-compliance. So it sort of begs questions: why would you use an umbrella company at all? Has a risk being liable for someone else's non-compliance? It's an excellent question, I suppose, Chris. What's your
Okay,
view on
well,
that?
I think there's two reasons. One, doing it yourself is actually extremely difficult. The calculations involved, getting the calculations correct is actually very complicated. So that's just one thing. And yeah, sure, you can go buy software and train people how to do that. The key thing is, in fact, and this is, the tax is the tip of the iceberg here. This is what we're talking about. So, and it's very important, clearly, but it's the tip of the iceberg. All the other services that an umbrella company provides to an agency, looking after the candidates, making sure the candidates are ID checked, right to work checked, all grievances being dealt with. And just to give you a small example, I'm not here to do Chris's job for him, but if you can imagine that an umbrella has to deal with a workforce of maybe 2,000-3,000 people, and off that workforce you're getting 2,000 or 3,000 timesheets, which some of which will change 5 times in a single week. You have to do multiple pay runs. It's hugely complicated, and in addition to that, all the other back office stuff that employment rights, which are bestowed on umbrella workers, providing those for yourself. Sure, many agencies do that, but it's phenomenally complicated, phenomenally time consuming. And I know the margins that are involved in this industry, and I can tell you, I've often been asked, how do I start an umbrella? And my answer is always don't. So it's a hard business, and I think it's fair to say, of course, you may think I'm biased, but I've 25 years both as a candidate contractor with FCSA as a looking after the consultants, and 3 years with FCSA now. It's a hard business, and I think actually umbrellas get a bit of a bad rep unfairly. So I think this will be done. Sorry, let's move on. I'm very conscious of time, but some interesting questions here. Expenses, right? Okay, so expenses is actually that's a thorny question. Presumably, you mean untaxed expenses, and untaxed and especially non-receipted expenses. The quick answer to that is that they stick out like a sore thumb on payslips, and bulk data in particular, Veripay, can easily say, well, this umbrella seems to be paying a disproportionate amount of expenses. But from an agency point of view, one of the issues has been that agencies said, oh no, just pay these expenses, please. We don't have receipts. We don't ask our candidates for receipts. You must. And in fact, FCSA accredited umbrellas are obliged to get those receipts and to make sure that expenses are only paid tax free of tax when they should be paid free of tax.
Yeah, with supporting evidence.
Yes, absolutely.
Just conscious of time, I know Maria had a hand up, but I'm not sure if she's still around. If you want to put that in there, there's still quite a few to go through. What I was going to suggest, Chris, if we take those offline,
sure, okay.
We've got contact details for each, so we will send the responses to those directly, and on your point on the margin only, we'll reach out through one of our CRMs to